Yesterday, the Ninth U.S. Circuit Court of Appeals heard oral arguments in the federal copyright infringement cases against the online music provider Napster. In July, a lower court issued a preliminary injunction against Napster, ruling it violated music industry copyright laws by allowing users to share music. You'll see arguments by the attorneys for Napster and the two appellees, A&M Records and Jeff Lieber Music. The hearing's 50 minutes.
Good morning, ladies and gentlemen. This is the time for argument in the case of A&M Records versus Napster, Inc. It's on appeal from a preliminary injunction entered by the district court. This court, a motions panel, stayed the injunction and ordered the case argued before the first available panel in October. And so we're here to hear this appeal this morning. And we note that each side has been given 20 minutes. We will not be excessively rigid in the application of the time limits, but we will attempt to stay within them. And we ask that you address us with the main points that you wish us to understand of your argument and the main points that should be addressed in opposition to your adversary. So we will proceed to hear the case. The appellant, Napster, Inc. Mr. Boyce, you may proceed.
Thank you, Your Honor. May it please the court, my name is David Boyes and I represent Napster. With the court's permission, I'd like to reserve 5 minutes of my time for rebuttal. The plaintiffs in this case asked this court to do several things that no appellate court has ever done in the history of the copyright laws. First, they asked this court to hold a company liable for contributory or vicarious infringement when the direct infringer is not engaged in commercial activity and does not have a commercial relationship with the contributory infringer, that is, with the defendant. Second, they asked this court to hold a defendant liable for contributory or vicarious infringement for supplying a technology that is capable of a commercially significant non-infringing use. Third, they asked this court to hold that consumers violate the copyright laws when they share on a non-commercial basis recorded music. The court must make that finding because without that finding there can be no contributory infringement. Fourth, they asked this court to hold an internet service provider liable for the infringing activity of its users when there is no evidence that the ISP did or could know which specific location is engaging in that infringing activity and where the ISP, whenever it received notice of a specific location with infringing activity, terminated that location. The plaintiff asks this court to reach each one of those four unprecedented holdings, and this court must reach each of those to find liability.
There's never been another case like this before, has there?
Well, Your Honor, I think the Sony case is very much like this case. The Sony case had a new technology. The Sony case advertised that technology, sold that technology for purposes of making copies of copyrighted works. There was no doubt, and the court found, both the dissent and the majority opinions found, that the primary purpose was to copy copyrighted materials, and that with respect to most of that copyrighted materials, there was no authorization from the copyrighted holder. This court, in the opinion that was ultimately reversed by the Supreme Court, found that that constituted contributory infringement. What the Supreme Court said is that copyright law is uniquely a creature of statute. It said so in the Constitution. Only what is prescribed by Congress can violate the copyright laws. Now, the court then went on to say there's a judicial doctrine of contributory infringement. Now, whether or not the court would re-examine that in light of recent opinions like the Central Bank of Denver case, where the court reversed several consistent years of lower court decisions that there was aiding and abetting liability under securities laws, saying if Congress has not specifically provided for this liability, it can't exist, is a question this court doesn't have to reach today.
Isn't there, though, a difference between the VTR user, the homeowner in the Sony case, and the Napster user here, though? Isn't there really a qualitative difference between the two?
I think there's a difference. I don't think it's a difference with a legal distinction. In other words, both are receiving a technology, both are controlling the use of that technology.
Well, in Sony, the manufacturer sold a recording device to the consumer. Correct?
Yes.
And that was pretty much it.
Well,
there was no continuing relationship after.
There was no continuing relationship, but there's nothing in the Sony case that says that, for example, Sony should have had continuing supervision, should have monitored it, should have removed the tuner. Sony could have removed the tuner.
How would you characterize Napster's relationship with the user here?
Napster is a supplier of a directory service that permits peer-to-peer sharing of files, music.
They just supply the technology.
They supply the technology, they supply the software that allows them to do that, and they supply an index that allows one user to find another user's files.
And that's the extent of their relationship with the user.
That's the extent of their relationship with the user. Now, they can, like every ISP, if they want to monitor it, they can police it when they get notices, and they have received notices, where people have said, these sites are infringing. And they follow the DMCA's procedures for terminating those sites. And they've terminated tens of thousands of sites on that basis.
Let me ask you this. In the Sony case, the Supreme Court focused on the private, essentially private use that was being made of these Betamax recordings. And so the district court in this case said that you cannot characterize a person who makes tapes available anonymously to anyone in the world who wants to use the technology. You cannot characterize that as personal or private in the same sense that the Supreme Court did in Sony. What's wrong with that?
I think that when the Supreme Court was talking about the personal use in Sony, what they were talking about is whether the unauthorized copying represented fair use. In addition to whether the unauthorized copy represents fair use in this case, there are clearly other substantial non-infringing uses. What the Sony court said is all it takes is for the technology to be capable of a commercially significant non-infringing use. Even if the district court was right in saying that some of the activity is infringing, as long as there is a substantial non-infringing use, Sony protects it. So that you have to look at two parts of the Sony opinion. One is the part that says, is time shifting, in our case space shifting, fair use? We think it is, because we think at least space shifting itself is private and personal, because in space shifting the user already has himself or herself access to the material. If you take the district court's opinion, you would find that some of the uses are infringing. But even if some of the uses are infringing, as long as there are commercially significant non-infringing uses, Sony applies.
Well, the district court said that 70 to 80% of the uses were infringing. Yeah. If that is true, can you still maintain that there are substantial non-infringing uses?
Absolutely, Your Honor. Remember, in Sony, the court found that it was sports programming was a significant non-infringing use, and that was 7.3% of all of the uses of the Betamax. They talked about the significance of having one movie that was uncopyrighted, My Man Godfrey. They talked about one television show, Mr. Rogers, that gave permission, and that was significant. They talked about one public television station that said 57% of what that public television station offered, and they said that was significant. So it's not what the predominant use is. This court, in the Court of Appeals decision that was reversed, said what matters is the predominant use. the Supreme Court said, no, it doesn't matter what the predominant use is. And that's particularly important in a changing technology. This is a situation in which the number of non-infringing uses is multiplying even as we speak. Because what is happening is more and more people are authorizing the use of their music on Napster. And what the Supreme Court was saying is you can't take a snapshot and say, how is it being used today? What you've got to ask is, what is it capable of being used for? Because otherwise, you're going to deprive the public of something that can be used for non-infringing uses. And remember, what the Supreme Court says is that in the copyright area, unlike the patent area that has a contributory infringement statute, it says the copyright area, this is court-made law. And we've got to be very careful about extending it because Congress has the power to determine what is copyrighted protection. But even in the patent cases, as the Sony Court talks about, a product to be subject to contributory infringement has to have no other purpose. And what the Supreme Court says, and I'll get that quote because I see the court raising its eyebrows at that. But what the court says is that, and this is on page 441, and it's talking about the patent laws. It says, unless a commodity has no use except through practice of a patented method, the patentee has no right to claim that its distribution constitutes contributory infringement. The court goes on to say, on page 436, a finding of contributory infringement does not, of course, remove the article from the market altogether. It does, however, give the patentee effective control over the sale of that item. Indeed, a finding of contributory infringement is normally the functional equivalent of holding that the article is within the monopoly granted to the patentee. Now, that's in the patent law where there's an actual statute. Even more so in the copyright area, unless a technology is within the monopoly granted to the copyright holder, to deprive consumers of a substantial commercially significant use is something that the Sony Court says simply cannot be done.
Counsel, do you make a distinction between a mechanical device and a service?
Your Honor, I think distinctions can be made in that connection. Is Napster
providing a mechanical device or a service or both?
Is Napster?
Yeah.
I think Napster is both. I think you can say it is when it provides a directory, it is providing a product. When it is providing the connections.
Well, product is different than service, or product is different than device.
Well, I was characterizing the product and device the same. I think you could make a distinction between product and device. I think you could say device is mechanical. The compilation
of a directory is a device, in your view, and for purposes of your argument?
I think that a device usually means something that's mechanical. I think that there isn't anything mechanical in Napster.
There's nothing mechanical in Napster? What's a server?
Well,
is it mechanical or is it a service?
Well, what goes to the Napster user is a service. I think that the server is obviously a device.
All right, so Napster is using a device, and your argument is we cannot enjoin the use of a server. That's improper under Sony, right?
You could not enjoin the use, my argument would be, of the Napster service that includes the server as well as includes the software that goes with it and the directory. I think
you think the directory is a mechanical device of some kind?
No, but I don't think Sony is limited to mechanical.
It's a compilation of intellectual material, is it not?
It is.
And that makes it a device?
No, I don't think it makes that a device. I don't think it makes it a device. I think it makes it protectable under the Sony doctrine. But I agree with the court that it's not a device. And if this court were to hold that Sony was limited to physical devices, then I think the court would hold that Napster, at least certain aspects of Napster, are not within that doctrine.
In fact, the VCR is clearly, from beginning to end, a device.
Absolutely, Your Honor.
Because it takes intellectual operators exercising intellect to make the darn thing work, right?
Yes, Your Honor. I can so testify.
We all can.
Particularly if you're going to use the timer.
The same is not necessarily true of a compilation of song titles and authors, is it?
No, but I think it is probably true, at least for me anyway, that operating the Napster service takes as much intellect as operating the VCR.
It seems to me that the district court took the position here that it was a series of service items that constituted the infringing conduct, and you mentioned just two of them, I think. You can think of no others the district court mentioned?
No, I think there are others, Your Honor. I think that what you have is a combination service that yields a certain result, but you can break it down into the directory. You can break it down to the server. You can break it down to the software that allows the connection with the server. There's also software that operates the server itself. So there are, I think...
And the delivery of it.
And the delivery of it, exactly right. I think there are a large number of those, many of which the district court did not deal with at all.
Okay. When one then turns to the injunctive relief, does this distinction take on some additional importance in your view?
It does in one sense, Your Honor, and that is that the injunction from the district court was one that says you must redesign your system.
Well, you argue it's so broad that you're going to have to shut it down.
Right, exactly.
And it seems to me that if you follow Sony and the VCR doctrines, you're going to operate mechanical devices till as long as you want, and in virtually whatever manner you want, so long as they're not contributing to the infringement by use of intellectual operation.
Well, we could certainly operate the servers without connecting them to anybody, but that would obviously be a useless exercise. I think what is being enjoined, and one of the reasons that we argue in the remedy section that the injunction is considerably overbroad, is because what it does is it enjoins the provision necessarily of both infringing and non-infringing material, and does so in a prior restraint.
Wait a minute, we're not talking First Amendment law and prior restraint, are we?
Oh, I think you are, Your Honor.
I thought we were talking copyright infringement and piracy.
Oh, no.
We're not?
Well, you are talking, you're talking that, and certainly the plaintiffs are talking about piracy, but...
You're not.
But I think...
You don't want to address piracy?
I'm happy to address piracy, Your Honor. We don't think this is piracy because we think it's lawful. But with respect to the First Amendment has never been interpreted to permit an injunction that prohibited the distribution of a directory service. That is, a service that goes to customers that says, here are the people that are prepared to share these files. First Amendment enjoins the distribution of copyrighted material all the time. But this directory service is not copyrighted, or if it is copyrighted, it's copyrighted by Napster. So what is being done here on the basis of what we think is a very overbroad prior restraint is to forbid, and again, in a way that no appellate court has ever upheld before, a distribution of intellectual information, intellectual knowledge, owned by and created by the person that's distributing it. So we think there is as we point out in our briefs, we think there is a significant...
You've used all but 3 minutes of your time.
May I ask
Okay,
one question at our expense and time, if you may? There is a criminal statute at Title 17-506.
Yes.
You were with the Justice Department. Are you aware of any criminal prosecutions that have gotten to the appellate level under that statute?
I'm not on the appellate level.
There are a number of district court ones.
There are some district court rulings, and I'm aware of one in Oregon that I think may be winding its way to this court. But I don't believe that there have been any appellate decisions. If there have, I'm not aware of them.
Okay, thank you.
We will give you 3 minutes.
Okay, Your Honor. Thank you. I want to come back to the first.
Do you want to reserve any time for rebuttal, or?
Could I take just 1 minute now,
sure,
and then reserve the balance? I want to come back to the point on why it's significant of this commercial relationship. As this court ruled in the Phonavisa case, contributory infringement, vicarious infringement come out of enterprise liability and respondeat superior liability. That depends on a commercial relationship between the direct infringer and the contributory infringer, and it depends on the direct infringer being engaged in commercial activity. Neither of those are present here. Thank you.
Good afternoon, Your Honors. My name is Russell Frackman of Mitchell, Silverberg, and Knupp, and I represent the plaintiffs' appellees in the A&M matter. With the court's permission, my colleague, Mr. Ramos, will speak for 5 minutes, and I would like to take the remainder. Judge Beezer, I think you had it absolutely right in your questioning with counsel in connection with the Sony matter, and I think counsel was all too modest in terms of what his client's system does.
Problems for you too.
I was hoping I could work on their problems first.
But are you prepared to discuss the knowledge issue?
Yes, I am, Your Honor.
I find that extremely troublesome. And, you know, you may have given notice of a couple of thousand works, but what are the millions of other works that are out there, and what of the legitimate releases, and what of the samples in fair usage? I mean, how if this is a service, is a concept I dealt with counsel, how are they expected to have knowledge of what's coming off some kid's computer in Hackensack, New Jersey for transmission to Guam?
I think, first of all, Your Honor, you start off that analysis of knowledge talking about what they designed the system to do. They designed it to be a pirate system.
Oh, they designed it for fair use.
No,
Samples.
No, sir.
Oh, they designed it for concert work that the authors really don't care about a copyright, even though they have it out on a recording. That's what they tell us.
No, that isn't.
I've read
what
their
they,
brief carefully.
That may be what they tell you now, Your Honor, but what they tell you in the documents, and the documents that Judge Patel relied on, is the following. Users will understand that they are improving their experience by providing information about their tastes without linking that information to name or address or other sensitive data that might endanger them, especially since they are exchanging pirated music. That is the co-founder of Napster writing what the system is intended to do, and it is exactly what the system has done.
Well, let me ask you this as a preliminary matter. Do you agree with Napster that the effect of this injunction as a practical matter is to shut down its operations?
I think, Your Honor, that to be perfectly honest with you, I don't know the answer to that. I think Judge Patel.
Well, let's assume it then for purposes.
I think Judge Patel didn't think it would shut down Napster. I think our expert doesn't think it will shut down, or I should say suspend Napster. But if it does, Judge Patel certainly thought, number one, that any damage to Napster was speculative as compared to the direct ongoing damage he saw to us. And indeed, Your Honor, Judge Patel made a finding that even if Napster suspends, they will be able, should they prevail ultimately at trial in this case, to restart their system. But whether or not Napster chooses to suspend what they are doing, I think, as this court has said over and over again, is not relevant even at the preliminary injunction stage. If they have created a situation where they either choose not to or cannot continue operation because of the massive infringement that is involved, then we as the copyright owners are entitled to injunctive relief expressly permitted under the Copyright
Well,
Act.
Napster argues you can't shut down the entire operation and essentially ban the technology if it's capable of substantial non-infringing use. Do you disagree with their reading of the Sony case in that?
Oh, absolutely, Your Honor. And that's actually where I was going to come in when I commented on Judge Beezer's questioning. Napster is nothing like the VCR in Sony, and I think there are a number of ways that that becomes clear. The first is to talk about what Napster does. Napster really is and was designed to be the gatekeeper of this entire system. That was their business plan because that's how they were going to make money. They were going to control the user's environment. They were going to be the content provider. Those are their words that Judge Patel quoted in her opinion. In order to do so,
well, just a moment. They don't have any control over what goes on before it goes on, do they?
In the sense of actually putting the material on, no. But in the sense of being the cause for that material to be distributed, they certainly do. No one can get that material without Napster. No one can get that material without being logged on to Napster. No one can get that material without Napster using its product, its server, for this particular service and purpose, which is the infringing purpose. There is a great distinction between the product, the server that Judge Beezer referred to, which I would equate to the VCR, and the service that Napster is involved in providing on an ongoing basis. It validates whether MP3 files are there by their users. It provides a checklist of quality and speed so their users can determine what to download. It verifies whether the MP3 file selected is available for transfer. It provides moderators to help the users. It queues up requests so that they can be completed. And last but maybe not least, it makes, and they brag about this, it makes everyone a server, a public server. They are involved in the distribution, integrally involved in the distribution to millions of people of millions of recordings, the overwhelming number of which are copyrighted recordings and copyrighted musical compositions owned by our clients.
Counsel, anything on an MP3 file go through the Napster system, or does it go user to user on a direct basis?
It doesn't go through the Napster system.
You don't even have their fingerprints. You can't find them on those things, can you?
The fingerprints you can't find because Napster doesn't want you
They
to
don't
find
touch them. They never have anything to do with it.
They have
my fellow in New Jersey and my fellow in Guam will have a direct connection on the internet, right?
But
and that's how the music is transmitted.
It is transmitted on the internet, and we are not trying to stop the internet, certainly.
Oh,
but
okay.
The only way...
So you concede that even on a copyrighted piece of material, one user can transmit from New Jersey to Guam through the internet, and it's not an infringement?
I don't concede that, Your Honor. I think it depends on all sorts of facts, including the types of facts that Judge Patel found here. That user, that Napster user, user one, could not connect to user, could not find user two, could not connect to user two, could not verify that user two has what he or she wants, all without Napster. Napster provides that IP address so that they can connect. There isn't any other way that they could do it. It's no different than saying that in my view at least, a case I know Judge Schroeder is familiar with and that I indeed argued in front of her some time ago, it's no different than the swap meet owner. He doesn't have his fingerprints on those cassettes. I'm just letting my swap meet be used to sell whatever I want it to be sold for.
This is really different from that because he could go in at any time and see exactly what was going on. And he could control what was going on in those premises. Here, Napster doesn't have any idea at any point in time what's being transmitted and what isn't.
Well, Your Honor, I would submit, number one, that they know what's being transmitted is copyrighted material, overwhelmingly copyrighted material. Indeed, as Judge Patel noted in her opinion, the executives of Napster downloaded copyright material. Their Digital Millennium Copyright Act compliance agent, Mr. Parker, downloaded innumerable pieces of copyrighted material. The same person who was charged with Napster for complying with the Digital Millennium Copyright Act is downloading infringing material. The same person who said the system is to infringe. And there isn't a case around that says that you have to know every single piece of copyrighted material that you are contributing to the infringement of. And I would submit in this case, Your Honor, the Fonovisa case is on point, because in the Fonovisa case, there certainly was no evidence that the owner of the swap meet did or could know every single copyright that the vendor was infringing by selling infringing material or counterfeit material. Indeed, it was just the opposite, and that has been the law, and they can't cite a single case and haven't cited a single case to this court or the district court that provides for specific knowledge at the time of specific infringements, although in this particular case they have that specific knowledge through their executives. Our complaint listed 200 copyrights. They're still all available on Napster. We sent them notice of 12,000 copyrights. They're available on Napster. And Your Honor, I would say finally on that point, the Digital Millennium Copyright Act itself supports our view, and we cited it and quoted it in our brief, but I think it's very important to Your Honor's particular question here. The legislative history of 512D says the important intended objective of this standard is to exclude sophisticated pirate directories which refer internet users to other selected internet sites where pirate software, books, movies, and music can be downloaded or transmitted from the safe harbor. Exactly, at least by analogy to what Napster is doing here. There is nothing at all that in the statute that requires specific knowledge on a case-by-case basis, or else you have exactly what transpires here. You make sure you don't have knowledge. Napster's original plans provided, and we cited this to the court, that they would have knowledge. They were going to market that knowledge. The demographics, they chose not to have specific knowledge, but rather to be content with the overwhelming knowledge that 80 or 90% of what they were distributing, permitting to be distributed, was copyrighted, and that is the basis on which they built the system.
Mr. Farr, even if you assume that and accept that, didn't Mr. Boyce has addressed there are other substantial non-infringing uses, sampling. He didn't address the new artist program, and I think there was one other one.
I would say, Your Honor, a couple of points on that. The court, of course, found that none of these were substantial non-infringing uses. As a matter of fact, having viewed an enormous record in this case, or potentially, I think here's part of the weakness in the argument. You say, well, we may be able to get consent in the future from some people, and therefore that permits us now to infringe almost everybody's copyright. That's not what substantial non-infringing use could possibly mean or be capable of. They could go out tomorrow and offer some people, I suppose, lots of money for consent. But that's not what it means. The court found it is not presently a commercially viable use, the new artist program. As a matter of fact, it represents only 1.2% of the copyrights that were being transferred. They say, well, maybe this can be used for the Human Genome Project in the future. So because in the future this system may be able to be used for the Human Genome Project, I can now create and implement and supervise a system that now infringes copyrights millions at a time. It doesn't make any sense. It's not what Sony stood for. It's not what the facts of Sony stood for. And it's not what the facts of this case show.
So you think that if there is a substantial infringement going on, the entire technology has to be closed down?
I think we are not, Your Honor, talking about a technology. I think I want to make that clear. We're talking about a business and a business plan. And in this particular business plan, implementing a technology that has been around for quite a while, and we told the court that in our papers. In this particular business plan, there is no commercial substantial non-infringing use. When you look through their documents over and over again, they talk about building a user base based on the quantity and quality of the recordings.
Does it have to be commercially viable in order to be?
The Supreme Court, I think here, the Supreme Court says, I think counsel conceded that it has to be commercially viable. The Supreme Court talks about commercial viability. The cases that followed the Supreme Court talk about commercial viability. I would submit that commercially viable or otherwise, there is no substantial non-infringing use here, and so you don't have to reach that point. I would also submit to the court, and just very recently, within the last 2 weeks, a panel of this court decided a case called the Worldwide Church of God versus the Philadelphia Church of God. I had to think I know who's going to win that battle, but decided a case in which the court said, and this was this court's description of the Sony case, under the unique circumstances of that case, to wit, copying of videotapes for time shifting for personal use to enable a viewer to see such a work which he had been invited to witness in its entirety free of charge. And Your Honor, the facts of Sony are unique, and the proof of that pudding is the tasting that when you go through the cases in 16 years since Sony, there's only been one case by my reading, the Vault case, that has upheld a defense based on a substantial non-infringing use staple article of commerce, and that was in very unusual circumstances where the use was expressly permitted by the Copyright Act under Section 117, permitting archival copies of software to be made. That's the only time. They say we're trying to narrow Sony, but Your Honor, they are trying to expand Sony way beyond the scope of Sony, way beyond the reasonableness of Sony. At bottom, Sony talks about doing what is just. When is it fair?
Let me ask you a question about fairness. Your clients are marketing what is being, as I understand it, what the users of Napster are getting are songs principally that are on copyrighted recordings. Your clients are marketing albums. They can't. I can no longer go out and buy a 45 record. I have to buy an album. So doesn't that mean that you're really, the fairness isn't all on your side here?
Not at all, Your Honor. My kids don't even know what albums are anymore. But you're talking about CDs, I think.
45, right?
Yeah, right. They know what a CD is, though.
That's our intellectual property. That's what we sell. That's what we've been selling for years. I told Judge Patel that I've been doing this for 30 years. 30 years ago, I used to go into garages where people were making copied 8-track tapes and putting labels on them. And we are working on trying to do part of what the record companies have spent so much time, and you've gotten an amicus brief from some of the people who are involved in that, is to try and work on a secure download capability. And we're doing the best we can. But Your Honor, one of the analogies I also made is I don't have to put a burglar alarm in my car to make stealing my car a crime. In fact, even before burglar alarms were invented, stealing cars were a crime. And if I left my car key in my car, stealing my car would be a crime. And the fact that we, among other intellectual property owners, and we're just one of a large group of intellectual property owners, as Your Honors know, interested in this case, that we can't stop them from doing what they're doing other than coming to court is why we're in court.
We understand that.
Counsel, are you aware of any complaints filed by you and your compatriots with U.S. attorneys where they have pursued criminal infringement against any infringer? using the Napster system?
Using the Napster system, no, Your Honor, I am not.
So they just ignore the problem, or you just don't complain?
Well, no, Your Honor. Here's the issue.
There's a criminal statute on the books.
Yes.
And at no expense to the record companies, I take it the government will file an indictment if there is a sufficient factual showing. And you're aware of no action taken by the government in this context?
Your Honor, I think the court, to a certain extent, put its finger on it in the Diamond Rio case. There are millions of people out there, millions of individuals. Enforcement in that way, even if we attempted to do that, we don't want to attempt to put an individual in jail for using the Napster system. We want to stop it by going to the source of the problem.
When I was a young lawyer, I talked to a detective for the telephone company that would go around. If they could get anybody jimming one of those telephones for the pay box, they couldn't wait to get to the prosecutor, because a little public education through a criminal indictment and conviction goes a long way to stop something that's illegal.
I think, Your Honor, we're seeing the public education right here today.
You're way into you've used
Yes.
almost all your
I apologize, Your Honor.
We'll give him a minute and a half anyway.
Thank you.
May it please the court, my name is Kerry Ramos. I'm here along with my colleagues Jeff Knowles and Aidan Sinnott on behalf of the plaintiffs in the Lieber action, songwriters and their music publishers whose works are being distributed on Napster without their permission. And Your Honor, I would ask some indulgence with my time, because I think the issues that I want to address are different from Mr. Frackman's. I will not repeat the points that he made and relate to the profound impact that Napster is having on my client's interests. For over 200 years, U.S. copyright law has recognized the exclusive rights of composers and lyricists to reproduce and distribute their musical works during the last 100 years, primarily in the form of sound recordings. As related in his declaration below, my client, Mike Stoller, began writing hit songs with Jerry Lieber in 1950. Mike was 17 years old. Elvis Presley recorded several of Mike's and Jerry's early classics, including Hound Dog and Jailhouse Rock. In the decades that followed, many recording artists, including the Beatles, the Rolling Stones, Aretha Franklin, and Barbra Streisand, have recorded their growing catalog of hits, including Stand By Me, On Broadway, Poison Ivy, Kansas City, and many more.
We are familiar with that. If you could get to the legal points,
Yes.
we'd appreciate being indulgent.
Well, Your Honor, this relates to the impact of Napster on songwriters. What is remarkable about their careers is that they were able to make a career out of writing music. It was not just a hobby for them. And it is a career for literally thousands of songwriters across the country. They depend on copyright law to compensate them for the use of their music, the distribution of their music, both in physical form through CDs and tapes, and on the internet. Songwriters generally want their musical works to be recorded and distributed. That is how they make a living, by licensing the recording and distribution of their songs in return for royalties, pursuant to Section 115 of the Copyright Act. In 1995, Congress amended the Copyright Act to make clear that the licensing provisions in Section 115, which relate to my client's copyrights, extend to digital downloads of songs on the internet. That was 5 years ago. Congress spoke regarding distribution of my client's works on the internet. Congress referred to those deliveries as digital phonorecord deliveries. And it said that my client has the exclusive right to license such deliveries on the internet. And that if someone makes such deliveries without my client's permission...
Counsel, are you saying there's no fair use? You said exclusive right.
That is
to the exclusion of fair use provisions of the Copyright Act?
Judge Beezer, obviously, the infringement provisions are subject to the fair use
Okay. And who
issues.
has, for purposes of an injunction, who has the burden of proving fair use? You showing a negative, or they showing the positive?
Well, Your Honor, I think the law is clear that the burden on fair use is on the defendant, on the alleged infringer.
Okay. That's contrary, I think, to Ninth Circuit law, but that's your position.
Well, I believe that, Your Honor, I believe that's the law as enunciated by the Supreme Court.
What's your best case?
Well, among other things, the Sony case. And more recently, the Acre-Froze case.
You will have to bring your argument to a close.
Yes. Congress's 1995 amendment of Section 115 goes on to say that such infringements are fully subject to the remedies provided by Sections 502 through 506, and 502 specifically provides for preliminary injunctive relief to prevent or restrain infringement of copyright. That is the relief that plaintiffs sought here and Judge Patel granted below, that Napster be preliminarily enjoined, not required to change the system, but preliminary enjoined from facilitating the digital downloading of plaintiffs' copyrighted works without their permission.
It wasn't just the plaintiff's copyrighted works, though, was it?
Judge Paez, yes, it was. In fact, we were asked that question. I was asked that question, and that was the relief we asked, only with regard to plaintiffs' copyrighted works, and that is very important.
You have no objection to an injunction which would be limited to specific works that would name the works that should be blocked, the titles?
Well, Your Honor, we believe that the injunction should extend to all of plaintiffs' copyrighted works. And
identified and unidentified.
Well, Judge Patel specifically ordered that the plaintiffs assist the defendants in identifying their copyrighted works. There are literally tens of thousands of these copyrighted works, and we have done so. We've complied with that. In fact, my clients have provided a list of all their copyrighted works.
All right.
The defendant has that.
Thank you. You have used your time.
Thank you very much.
Thank you.
Judge Beezer, let me direct my first response to your question, and that is on the burden of proof. We agree, as we indicated in our brief, that Ninth Circuit law is very clear that the burden of proof is on the plaintiffs who are seeking a preliminary injunction. The district court erred in that, placed the burden of proof on us, and as a result, we think their reliance on these factual findings is entirely misplaced in this case.
Isn't it just that they're likely to prevail on that affirmative?
Yes, but they have to be likely to prevail, but they must bear the burden of proof that they are likely to prevail on each one of these items, including our defenses, and she put that burden of proof on us.
How about at trial?
That's what we're looking for, Your Honor. And we're looking for a trial without being shut down while we're waiting for the trial. We want a trial as fast as possible. That's what we've asked for.
But at trial, who will have the burden of showing the affirmative?
At trial, we'll have the burden of proof on some issues, but with respect to Judge Beezer's question on fair use, they will have the burden of proof, and Sony says so. At page 451 of the Supreme Court reporter, the U.S. reporter, because what the court is dealing with there is that where there is a non-commercial use, and there's no doubt that the consumers here are engaged in non-commercial activity, and they're the ones that are alleged to be engaged in direct infringement, the likelihood of harm must be demonstrated by the plaintiff, and that's what the court holds in the Sony case. So with respect to burden of proof on fair use, in terms of the consumer's fair use of the music, they will bear the burden of proof.
Well, at trial, they don't raise fair use.
No, but you
raise it.
We raise.
You have the burden of raising it.
We have the burden of coming forward and raising it.
Right.
But then they have the burden of proving that there will be the substantial harm as a result of the fair use because the consumer's use here is non-commercial.
You're arguing the burden of proof shifts?
Well, the burden of proof, the burden of going forward, as they used to tell me in evidence, is on us. But the burden of proof, in terms of that particular aspect of the defense, the Sony court says is on them. They said that the district court had found that none of the uses were substantial. That's simply not true. In fact, at the conclusion of the hearing, the court said there is a lot of space shifting going on. She said that wasn't the predominant use, but she said there's a lot of space shifting going on. And space shifting is what this court in the Diamond Rio case held was clearly fair use because it simply involves a consumer who already has access to a particular piece of music getting that music in another form or in another place. And if there's a lot of space shifting going on, that's a fair use. That's a non-infringing use. And with respect to the new artists program, the new artist program is just one aspect of where people, both new and old artists, give permission. And there are now over 20,000 artists who have given permission to have their works shared. Now, anybody who is sharing those works is engaged in a lawful activity. And to eliminate the entire peer-to-peer technology prevents that kind of sharing from continuing. The only other point I would do is to pick up on the Vault case, which counsel mentioned. The Vault case is a very important case. That is a case in which the Court of Appeals for the Fifth Circuit held that Sony compelled the result of continuing to permit the sale of a device whose primary and predominant purpose was to enable the copying of copyrighted materials without authorization, because there was one single very limited use that was lawful, and that was making one archival copy. This amount of fair use goes way beyond that.
Thank you, counsel.
Thank you, Your Honor.
The matter just argued is submitted for decision. The injunction remains in effect, or it stayed pending further order of the court. That concludes the court's calendar for this morning, and the court stands adjourned.
All rise. Excuse me again, counsel that is going downstairs to speak with the press. If you'd like to stick around for a minute, please, I'll lead you downstairs to the press room.
Next on C-SPAN, a House panel hears about crime prevention strategies from law enforcement officials and academics. This morning at about 5:40, a protest of tonight's presidential debate from supporters of third-party candidates not included in the event.